Good afternoon. I'm Richard Roos-Collins, Director of Legal Services for the Natural Heritage Institute, which is a public interest law firm based in San Francisco. My thanks to Jeff Mount and Sarah Knoll for organizing this workshop and inviting me to participate. My thanks to them and to you for permitting me to participate in this electronic manner. I really regret not being there in person. I think your lineup of speakers is terrific. In any event, I have an unavoidable conflict, so you've got me on the screen for about 15 minutes to cover three topics. First, what are the fundamentals of hydropower regulation by the Federal Energy Regulatory Commission, or FERC? Second, what's the state of the art or science, particularly with reference to climate change? And third, what's the future? So I'll cover those topics in roughly 15 minutes and hope that you learn from this what I would have otherwise presented in person. So, fundamentals. The Federal Power Act was enacted in 1935 to regulate all non-federal hydropower projects in the nation. It requires that each project be best adapted to a comprehensive plan of development for all beneficial uses of these lands and waters, including power generation, flood control, water supply, navigation, water quality, recreation, fish and wildlife, and so forth. Each licensing decision is adjudicatory. Now, forgive me for using a six-syllable legalistic word in a workshop mostly for scientists, but it's an important concept. Adjudicatory means that FERC is acting like a court. It is, in a licensing decision, it determines the rights of the licensee to build, operate, and maintain a specific project. Only FERC can make that decision, and then if anyone disputes the decision, it's appealable to court. In the meanwhile, or in the first instance, FERC is functioning like a court to adjudicate whether a project will be licensed, and if so, on what conditions. Because its licensing decision is adjudicatory, it's based on substantial evidence in the record. Now, the record consists of a docket, which you can now see online through eLibrary. The docket shows each document filed by the licensee or other stakeholders in the proceeding. That record, at the end of the day, is the basis for FERC's decision. The Federal Power Act requires that its resolution of each factual issue, for example, how a project will affect the downstream habitat for trout, its resolution of each factual issue must be based on substantial evidence in the record. All parties may contribute to the record. And the record must be compiled on a clock. And by that I mean this. 5 years before the original license for a project will expire, the licensee must notify FERC of its intent to seek a new license. That notice then triggers 3 years of studies to evaluate baseline conditions and also how a new license may affect those baseline conditions over the term, which is not less than 30 or more than 50 years of a new license. FERC will, from time to time, permit the studies to go on longer, but the rule is 3 years for completion of the studies of baseline conditions and probable future conditions. Last fundamental you need to know for the purpose of this workshop: FERC has jurisdiction over the licensee and its project. It does not have jurisdiction over any non-licensee, whether American Rivers or the California Department of Fish and Game or any individual who may submit evidence. Of course, we all have to follow the rules of practice and procedure when we appear before FERC, but FERC's jurisdiction, meaning its authority to enforce action, is limited to the licensee and its project as specified in the license. So what's the state of the art or science? I'm going to start generally and then move more specifically to the treatment of climate change. In 2005, FERC adopted what is called the integrated licensing process. This distinguishes it from the alternative licensing process that was adopted in 1997 and the traditional licensing process which has been in place really since FERC became an agency in 1935. It's called integrated for a couple of reasons. It really emphasizes cooperation between the licensee and the stakeholders in the conduct of the study plan and even in the negotiation of the conditions of a new license. Even more importantly, it calls for cooperation between the federal and state agencies and FERC in the conduct of the environmental review under the National Environmental Policy Act and the counterpart state laws. It also emphasizes the clock. The integrated licensing process is a fast train. You get on it, you stay on it. You can't get off and get back at your leisure. It really is intended to produce a decision on time, which for a project with an original license means before that original license expires. Now, FERC in the last 5 or 10 years has really outdone most other federal and state agencies in the volume of its evidentiary record. FERC really does encourage the licensee and the stakeholders in a given proceeding to produce studies on a wide variety of topics that go to the public interest determination. It will accept evidence from any stakeholder, and today it is typical for a relicensing record to be 5 linear feet or more in a filing cabinet. Now that doesn't necessarily mean quality, but it does mean that FERC permits almost any evidence to come in the door and be considered in the licensing decision. That record is intended to cover all of the regulatory decisions, not just the licensing decision. So under the Clean Water Act, Section 401, the state is required to certify that a project will achieve water quality standards. The record that it needs for that certification decision is intended to be produced through the ILP by the licensee in cooperation with the state as well as other stakeholders. Another critical thing about FERC's current practice, it really does emphasize settlements versus disputed decisions. Now, as recently as 10 years ago, that wasn't so. As recently as the late 1990s, most licensing decisions were disputed, which meant that the licensee submitted evidence and the rest of us submitted evidence.